If you're on a deed with someone else, can they make a new one without you in it, without your permission? So I'm going to take these up one at a time. The first question is, if you're on a deed with someone else, can they make a new one without you in it? So whether or not someone who you own a property with can make another deed later in time after the two of you sign depends on the type of ownership you have with the person. So there's a few different ways that people can own property. One way here in Florida is if you're married couples own property in a manner that's called tenants by the entireties, or tenancy by the entireties. So that basically denotes that two spouses own property together or own property jointly. That can only be done if the deed itself refers to the two people as a married couple, or references that the person, has a spouse, or it says, so-and-so joined by his spouse. Anyway, it basically has to say that you're married in some form, or that you do have a spouse, or that you have a wife, or that you have a husband. In that case, it's a joint type of ownership, much like a joint account, where one person couldn't do a replacement deed without the other person knowing, meaning both people always have to sign any type of deed. Another way to own property is as joint tenants with rights of survivorship. And again, when you own something jointly, any deed that gets signed related to that property thereafter would have to be signed by both owners. So you don't have a separate interest in the property that you can give away. Joint ownership, or tenancy by the entireties, which is also like joint ownership, it's as if both people on the deed, or the people on the deed, own 100% each of them, because the way it works is after one person dies, the other person takes full ownership. In a joint tenant situation where we don't have a married couple, even if we had 6 people on the deed as joint tenants, right? When one dies, 5 own it. When another one dies, 4 own it. Another one 3, and so on and so forth. So it's as if each individual owns 100%, even though we have 6 names on the deed. In that scenario, you can't have any other deed that comes after that one that you signed without all 6 owners, or all the owners signing it. However, you can own property in Florida as what's called tenants in common. This is not a joint ownership, but it's a type of ownership where an individual owns an undivided portion of the property. So I'll give you an example. Let's say there's 2 people on the deed, and they're named, Bob Smith and Kate Allen as tenants in common. So this means that Bob and Kate each own an undivided half share, or 50% interest in the property. So they each have 50% that either of them can do whatever they want with, right? So if Bob wanted to go and sign his 50% over to someone else, or convey it, deed it to someone else, he can. And guess what? Kate's going to be owning property with someone else. Kate can do the same thing, right? You have your own interest. You can do what you want with your interest, if that means signing a new deed where someone else takes over your interest. But that brings me to the second part of this question: without your permission. So yes, they can sign a new deed as to just their portion without your permission. However, they can't just take you off the deed without your permission. So they can't make a new one, which is in the first part of the comment, like a brand new deed that replaces everything, meaning you were no longer on it if you were originally on it, without your permission. In order for 100% of the property to go to someone else, in that scenario, you each own 50%. The person who does something without the permission of the other can only do it with regard to their 50%, not your 50% too. Now, they can go and do whatever they want with their 50% without your permission and without you knowing, but they can't do a whole new replacement deed that covers all 100% because you own 50%. So that 50% is yours, and you can do whatever you want with your 50%. But again, in a tenants in common scenario, they can do whatever they want with their 50%, meaning you each own that undivided interest. One thing to look out for, and this is like my tip, be very careful. People often do not realize this. If the deed doesn't specifically state that you're joint tenants with rights of survivorship, if it doesn't say those specific words on the deed, then you are tenants in common, meaning you each own a specific share, right? So if you weren't specific when you had the deed drawn up and it just has your names, right? It just has two people's names and nothing else after that to say they're joint tenants with rights of survivorship, or they're a married couple, or tenancy by the entirety, then it's going to be looked upon that you each own your own 50%. So a person in that scenario where it says nothing at all, or it specifically says tenants in common, they would most likely be able to go to a law firm or go somewhere and get a deed for their 50% if they want to give it to someone else. Now, that being said, lawyers should question this. It is a little fishy or weird to come in without the other person on the deed, so other questions should be asked. But could they potentially find someone, or could they just go down to the courthouse themselves, or just print a quitclaim deed online to give their 50% away and record it? They could. So this is why it's so important that when you form a deed or you get a deed prepared, you do it with an attorney and you make sure the right ownership language is in there, because if you don't, you can be setting yourself up for problems down the road. All right, I hope this answers this question. If there's any other questions about deeds like joint ownership or tenancy in common, or anything at all to do with deeds or estate planning in general, and you live in Florida, don't hesitate to reach out to our office. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.